SJC-11772, Charlene Galenski v. Town of Erving, and another.
Good morning.
Good morning, Chief Justice, Associate Justices. May it please the Court, my name is Patricia Rappenschak from Robinson Donovan, and I represent the appellant in this case, the Town of Erving. This case presents a question about the scope of authority that municipalities have to enact regulations pursuant to Chapter 32B, the statute which provides for group health insurance for public employees and retirees. The issue before the court today is whether a policy which was enacted by Erving, which limits eligibility for town contribution to health insurance during an employee's retirement to an employee who has worked for the Town of Erving for at least 10 years. As an aside, that policy also provides that the retired employee can remain on the town's health insurance, but is required to pay 100% of the premium unless that employee has worked for the town for at least 10 years.
In this case, Ms. Galenski obviously worked for other school systems for a very long time. If you were to prevail, would she doesn't, since she retired from Erving, she doesn't have any right to become a retiree of either Deerfield Valley, either of those other two, does she?
That's my understanding, Your Honor, that she would not be able to retire from either of those other two districts, since she was not working in those districts at the time of her retirement.
So, okay. So if they had the same, well, yeah, all right.
So, but what I don't quite understand is how the statutory scheme, particularly that portion of Section 9E, which provides a solution for a municipality like the Town of Erving to get reimbursement from other. This way, the retiree is just completely out of luck, even though she's had 30 years of work experience for various towns. She gets no health insurance reimbursement at all from anybody. Whereas if the Town of Erving paid, as it would for other retirees, it could get reimbursed from previous municipal employers. So there is a statutory remedy for Erving other than a policy like this.
There is, in fact, the possibility under, or the likelihood under Section 9A.5 that Erving could seek reimbursement at whatever rate the other municipalities had set for contribution from those other municipalities after paying up front.
But why should it be the employee rather than the town who takes it in the chin?
Your Honor, this is really a question of statutory interpretation.
Right, and the statute deals with a way for which a municipality can get reimbursed.
I believe that we have to start with Section 9 because that really is the section that's at issue here, not 9A.5. Section 9 is the section of 32B that provides generally for the availability of health insurance for retirees of municipalities.
And it says that the policies shall provide that upon retirement of an employee, they continue to get health benefits, right? Doesn't it?
Well, the statute actually, it's close to that, Your Honor, and I actually wrote it down because I thought that language was so important. And leaving out language from that section of Section 9, which doesn't apply here, it essentially says that the policy or policies, referring to those policies purchased by the town, of insurance shall provide that upon retirement of an employee, and I'm paraphrasing a bit here, the group insurance shall be continued and the employee shall pay the full premium cost, subject to the provisions of 9A and 9E. That language of that statute has been interpreted twice by appeals courts. First by by the appellate court in the McDonald versus Southbridge case, and then secondly by this court in the Seoc versus Ludlow case. And both of those cases found that that language did not refer to compulsory insurance coverage for individual retirees.
Both of those cases, if I recall correctly, the two employees didn't try to become members of the retirement system until after they had retired.
That's absolutely true for SIAC. I'm not completely sure if that's the case for McDonald based on the facts, but it is absolutely true in McDonald that the employee was not enrolled in the town's health insurance as an active employee during the course of his employment. There's no question.
You chose 9E. I mean, your town chose 9E. Why isn't a solution here to lower the rate for everybody? I mean, you already did it once from 79 to 77, if this is such a problem.
Well, it's certainly an option that the town could have taken, and the town could still take that option of going forward and reducing the rate for everyone. The question here is whether the policy that was enacted by the town, the one that was referenced at the beginning, is reasonable and not in conflict and not inconsistent with the language of Chapter 32B and specifically Section 9.
Are you essentially saying that, well, we passed a bylaw that says, guess what, they didn't retire from here, hands off, nothing applies?
No.
No. I thought you're actually claiming that Section 9 doesn't even apply. That you're not required to continue health insurance.
What we're arguing, Your Honor, is that pursuant to the court's opinion in McDonald and in Seoc, both of those courts held that it's not unreasonable to allow a municipality to define eligibility for town contribution to health insurance during retirement, or in fact, in the case of Seoc, to define eligibility for inclusion in the group policy at all. And it is, in fact, that is what Erving was attempting to do by enacting its policy, to define eligibility before an employee can become eligible for the town to contribute the 77% or whatever that percentage is. That employee has to work for the town for 10 years. It's a definition of eligibility for that policy that the regulation seeks.
So is Ms. Galenski an employee who is retired from the service of the town?
Yes.
I'm sorry, did you say is she?
Galenski, an employee retired from the service of the town?
She is.
So she then falls within the 9E scope because that applies to employees retired from the service of the town, correct?
Correct.
But
9E refers back to Section 9.
Okay, but don't you have the problem is that 9E says you cannot pay a different rate to any group or class within that government unit, and you are paying 0% for the class of persons who have retired from the service of the town with less than 10 years, and 77% for those who have retired from the service of the town who've been there for more than 10 years. And how does that not violate 9E?
Well, that section of 9E, Your Honor, I think needs to be looked at with the legislative history and the purpose of that section in mind, number one. And it's clear from the legislative history that the reason that language was inserted into 9E was to prevent various collective bargaining units from bargaining different rates of insurance for their members within a single municipality.
But the language says what the language says. I mean, it's pretty clear, isn't it?
I would disagree, Your Honor, because if you were to read the language in the way that's being suggested here today, then clearly the court's decision in SIAC would have created another class of employees who was not being treated the same. Employees who chose not to enroll in the retirement health insurance at the time of their retirement. There's still employees who retired from the town, just as Ms. Galenski and someone who opted in. So I don't believe that language means what's being suggested.
I'm sorry. Could I ask you to go back to Justice Link's question about 9A.5, because I'm wondering if the reasonableness of your policy should be looked at in the context of the entire statutory scheme. And if you have 9A.5, which permits the town to collect from other towns where the employee may have worked, why doesn't that detract from the reasonableness of a policy which has an arbitrary cutoff of 10 years, especially as it applies to somebody who's worked for other towns, not this one, for over 30 years? I mean, how can your policy be reasonable if you have an alternative that's put there right in the statute? And don't tell me go back to Section 9, because that's not an answer.
Okay, I wasn't going to say that, and I won't. There's no question that Section 9A.5 does provide some relief to a town in a situation like Erving's. The relief is, I would suggest, imperfect. The town, the last town, the one from which the employee retires, bears the burden of paying the full cost of the health insurance each year, and then also bears the burden, the administrative burden of then having to seek reimbursement from each of the other towns for whom the employee had creditable service. There's no particular mechanism in the statute that provides for collection other than it says that the town may file, essentially may file a suit and contract against another town.
How about sending Deerfield a bill?
Well, that would be step one. For
the amount that, what's so hard about that?
Let's say it depends on how many employees there would be, in any given town that may have had creditable service. I mean, it presents an administrative burden for an employer to do that.
But don't you think the legislature contemplated exactly that?
It did, Your Honor. I mean, it absolutely did.
What's the problem? I mean, and the legislature seems to me to have made a choice to deal with the very situation that's in front of us.
It's certainly there to address it in part, and we would not disagree that it provides some relief. The other two parts of it...
As opposed to having no relief for someone in Ms. Galenski's position.
That's correct, as opposed to having no relief. In any given situation, however, any town may have chosen a much lower rate of contribution toward that employee retirement health insurance than Erving, or whoever the town is that is seeking it.
How low can they go if they've accepted these provisions? 50%?
If they haven't accepted either 9A or 9E, they don't have to contribute at all.
But, I mean, that's up to them.
That's up to the individual towns, that's correct.
And so if the town has made that choice, I'm still confused as to why this suddenly becomes the employee's problem.
I take it you're suggesting that other towns where this person may have worked may not have elected 9 or 9A or 9E.
Right.
Therefore, they wouldn't be liable to reimburse you for anything.
That's correct. Or they might be liable for reimbursement at a significantly lower rate, because the statute does provide that the reimbursement is at the lower of the rates of whatever the towns have set. So yes, while it does provide some option for relief, it certainly doesn't provide all the relief necessary for a town with fiscal concerns. And I must emphasize again, and I think Your Honors are aware that this is a significant unfunded liability for many of the municipalities in the Commonwealth, and as cited in a study noted in the brief, that unfunded liability for the Commonwealth exceeds $40 billion at the moment. So this is not an insignificant concern for the municipalities.
If the town of Erving had not adopted Section 9 and 9E, or
Yes.
whatever combination they had to do, and hadn't bought into the statutory scheme at all, could the town, under its home rule powers, have devised its own scheme for payment of health insurance for retirees?
I don't think so, Your Honor.
But you're relying on the home rule amendment for the authority to do this.
Correct. Correct. I don't think that Erving could devise its own scheme consistent with the home rule authority, in part because of Section 15 of Chapter 32B, which makes it clear that this is the exclusive way that municipalities can provide for health insurance.
So if you could not exercise home rule authority to pass the bylaw that you did, would you have to pay the plaintiff in this case
No, not if we had not adopted.
No. If you had not adopted your own regulation under home rule, you're claiming that you were authorized to do what you did because of home rule.
Correct.
If you did not have that authorization, you would be bound by the straight language of the statute.
If we were not authorized under the home rule authority to enact this regulation, then we would be bound by the statute.
The language of the statute. And where under the language of the statute can you do what you have done?
Well,
Or do you need home rule to do this?
Well, I mean, Section 14 of the statute provides municipalities with the authority to enact regulations for the administration of this whole statutory system. But really, I think the true authority does come from the Home Rule Amendment that allows municipalities, and it's a strong home rule amendment. It gives municipalities the authority to enact regulations not inconsistent with the Constitution or the statutes, and it's our position that this is not inconsistent with the statute in question.
All right, thank you.
Thank you.
Chief Justice and Associate Justices, may it please the Court, my name is Eric Lucentini, and I represent the appellee, Charlene Galenski.
Can I ask you this? Is it your position that the town could not have enacted any requirements of this type for participation in the subsidized health program?
Well, I guess maybe that's a little bit of a difficult question to answer, Your Honor, without it's very fact-specific, let's put it that way.
1 year.
Excuse me?
1 year.
No,
not
absolutely
10 years.
not.
1 year.
No tenure requirement
No tenure
whatsoever
requirement.
is acceptable under
So
the statute.
your client, or not your client, but an individual in the retirement system, is it the teacher's retirement system?
Teacher's retirement system, yes, Your Honor.
Works 30 years for a town that has not adopted 9A and 9E, and therefore really is not going to get any subsidized health care when they retire, gets a job with your town and 1 month in retires, and to get 77% of his or her insurance subsidized. That proper? The town can't do anything about that?
I am not aware of anything under the statute that, I shouldn't say the town can't do anything like that. What I'm saying is the town cannot impose a tenure requirement to achieve that result. The town certainly, and let's put it this way, what the town could do would have to be stacked up against what the express mandates of the statute are. I mean, the statute has some very clear language in there as to what towns have to do. So if it turned out, and I've never, and by the way, I'm not aware of any case that's come up in the Commonwealth where something like that has happened, among other reasons because every single town in the municipality has in fact adopted either 9A or 9E at this point.
So they adopt 9A and 9E, but they elect to pay only 50%.
Minimum 50%.
At minimum
correct.
50%.
Yes, and that's actually pointed out in the Special Commission's report. It's noted actually in the Special Commission's report that came out to study retiree health benefits back in 2013, that indeed all of the municipalities at this point in the Commonwealth have adopted 50% or more.
So when the municipality decides to hire someone, regardless of how long they stay, if they retire under the teacher retirement system, they're going to get what you say the town has agreed to pay.
They're going to get exactly what the statute requires, and that's exactly right, Your Honor. And in this case, there is no doubt whatsoever that Ms. Galenski was entitled to both continued access and continued contributions under the statute. The reason is very simple. She was an employee under Section 2. There's no dispute about that. Section 4 of the statute contemplated that she would be automatically enrolled in the town's insurance scheme unless she opted out in writing, which she did not. Section 9 provides on its face that the coverage shall be continued. It's an express mandate. There's no doubt about that. And it provides, and it actually incorporates by reference with and interlocks with Section 9E, which the town also adopted, which provides for the town's contribution rate. That's the contribution part. So it's access and contribution. Actually, there's something, with respect to the town's position and the appellant's position on that point, that they can allow my client, Ms. Galenski, to continue to access the policy, but just paying for it out of her own pocket. There's something actually analytically inconsistent with that internally as well. because they've conceded that she is entitled to continued access under Section 9. They have actually conceded that in these proceedings.
How could they not?
So they are, exactly. But at the same time, they're taking the position that having allowed her, not allowed her, but in a scenario where she is entitled continued access, they can somehow pick and choose which portions of the statute they're going to be bound by. Section 9 incorporates by reference Section 9E. It expressly says on its face, this section shall be subject to the provisions of Section 9A or Section 9E, depending on which, if any of those two, the municipality has adopted. So it incorporates by reference Section 9E.
Could you give us some examples of the kinds of regulations that cities and towns have adopted, I think under Section 14, to kind of flesh out issues that have come up under Section 9E?
Your Honor, I'd be happy to speak to that. Two very instructive cases, I think, where town policies were upheld, or where the ability of a town to enact policies was upheld, are the Siach versus Town of Ludlow case and the McDonald case, which are really analytically of a piece. And what the court was saying, what this court was saying really in both cases, actually the McDonald case involved review by this Court of an Appeals Court decision that was very, I think, thoughtful. But in both of the cases, what the court was confronting was this scenario. Somebody comes in after retirement and decides they want to enroll into the town policy. And the statute does not speak to that. The statute is actually silent on that. And in fact, in the Siach case, this court actually went out of its way to note that. They said, and actually they said it in McDonald as well, the statute doesn't speak to this situation. And if the statute doesn't speak to the situation, the town is certainly empowered to seek a reasonable resolution of that situation. Now, I actually would have gone even farther. I would have said the town is obligated to regulate in that situation, because Section 14 of the statute actually mandates that towns shall implement reasonable regulations to administer the statute. So if there is a lacuna in the statute, the town actually kind of does have to step in order to achieve the goal of uniformity under the statute. So the result there was it is perfectly reasonable and understandable, especially with, and it is understandable that municipalities have cost containment issues. And it's certainly reasonable that towns would look at somebody who is, coming in 5 years, in the Koch case, it was 5 years after the fact, coming in and saying, hey, I see some benefits here, let me enroll in this policy. And a town would say, no, we need some finality. By the way, that was not expressed in the court's decision, but I think that is the backdrop there, that, what is reasonable. Because where the statute is silent, reasonable regulations will be upheld. There is no question about that. I think the problem with the appellant's position here is that they don't really get to argue what we did is reasonable, because they have an antecedent problem here. And the antecedent problem is that what they did directly violates multiple provisions of the statute, directly frustrates overarching goals of the statute, including uniform enforcement, and the general scheme of a guarantee of continued access to employees who buy into the system over the course of a career. And so they can't then simply say, well, we have a reasonable resolution, and our reasonable resolution is to cut entire chunks of the employee base out of this scheme. That's reasonable in an abstract sense, perhaps. They may feel that that's reasonable. But you don't even get really to that part of the analysis if the statute contains a mandate and the regulatory action or the policy directly frustrates the execution of that mandate.
Let me ask you a question. Did Ms. Galenski, was she informed of this town policy prior to accepting employment
She
at the town?
absolutely was, Your Honor. Yes, she was.
I thought it was adopted the same day she started her job.
I'm not sure whether it was the day she started, but it was around that time, Your Honor.
But she took the employment knowing that this policy was in effect.
She absolutely did, Your Honor. And my answer to that would be, I guess, twofold. First of all, she was not a lawyer and had no way to understand necessarily what the impact on her and her future years in retirement would be of this policy, one, or whether the policy was indeed basically lawful or not. And secondly, I think in a case like this, what's particularly interesting is who is going to challenge a policy like this, if not an employee? Who's going to have standing to challenge a policy like this, if not an employee who actually bought in and then was actually denied the benefits. What I would also point out is, well in advance of retiring, she actually notified the town that she did not believe actually that she had consulted about this policy and did not believe that it was lawful, and this is sort of going over the record, so to speak, but attempted to resolve this issue with the town well in advance of retirement. Again, a scenario very different from Koch, McDonald, in these cases where post-retired employees later on down the line decide that they want to come back in under a policy. She was, to be absolutely clear, 100% vested into the system during the entire course of her career at all times. She was vested into the system. She was the model of the individual who gets coverage under the statute.
Do you happen to know what the two prior employers in Deerfield Valley, what their percentage is?
I actually do. They are in the 70s, I think. There's Deerfield and Shelburne. I looked into it at some point. They're both above 50%. I believe they're in the 70s. I'm not sure exactly where. I thought that Deerfield might have been 79, I think.
When was 9A.5 adopted?
2010, Your Honor.
And what was the genesis of that?
I think the genesis of it is that municipalities actually have a reasonable concern here about costs. I mean, I am actually sympathetic to that. I see that towns, I don't think it's necessarily a correct outcome that a town would be on the hook for the entirety of a career. And this was the legislature's, you see the legislature actually here grappling with this issue of cost containment and offering solutions. And that really gets to one of the most problem aspects of this case, which is that if towns can step in with policies of this sort to vitiate the legislature's attempts, perfect, imperfect, whatever it might be, to resolve the problem, then that essentially does away with any need for legislative involvement, and that's simply not how the system works. I mean, we have a rule of law here. The legislature addresses these problems, and we move toward perfection.
All right, thank you.
Thank you.